You're watching the Florida Channel, a public service of the Florida Legislature, WFSU-TV, and Florida State University.
Hear ye, hear ye, hear ye. Supreme Court of Florida is now in session. All who have cause to plead, draw near, give attention, and you shall be heard. God save these United States, the great state of Florida, and this honorable court. Ladies and gentlemen, Supreme Court of Florida, please be seated.
Good morning and welcome to the Florida Supreme Court. The first case on our docket today is Walker versus the state of Florida.
May it please the court. Good morning, Your Honors, Madam Counsel. My name is Raheel Ahmed, and I, along with my co-counsel, Ms. Carol Rodriguez, are here on behalf of the appellant and cross-appellee, Mr. Robert Shannon Walker II. This case comes before this court on an appeal by Mr. Walker of the Postconviction Court's denial of his guilt phase claims pursuant to his motion to vacate pursuant to the 3851 Rule of Florida Criminal Procedure. The cross-appeal comes before this court by the state of Florida on the post-conviction court's order granting Mr. Walker, correctly granting Mr. Walker, a new penalty phase for trial counsel was ineffective for doing a reasonable mitigation investigation and for presenting that investigation during the penalty phase. I'd start with this court with the two arguments presented in Mr. Walker's initial brief regarding the guilt phase claim. Mr. Walker argues to this court that the post-conviction court erred in summarily denying the guilt phase claim, specifically, first, that trial counsel had failed to timely object or to file a motion in limine to exclude testimony and evidence, photographic evidence, of apparent blood stains, which were not relevant because it had not been proven whether or not those stains were blood stains.
Tell me how those blood stains or supposed blood stains outside of the building really prejudiced your client. I mean, it seems to me that in this case, what we had was a bloody beating. This guy runs out, he's covered in blood. You know, the clear inference is, of course, that all these stains are in fact blood stains. And so even if the trial attorney should have done something and made some objection about it, where is the prejudice in this case from his failure to do?
The prejudice is clear, Judge. When we look in the record and appeal, specifically after the testimony comes in through Agent Laufenberg about the apparent blood stains, the first, when the state shows Mr. Studstill, the trial counsel, the photographs, he says no objection being tied in. And the prosecutor responds, Judge, I believe we've tied it in through that neighbor, Mr. Goss. The court at that point takes out the jury and has a conference with the two attorneys.
Did we have someone who actually testified that the victim, in fact, somehow got out of the apartment and fled the scene?
There's no eyewitness testimony as that. There's testimony by Ms. Leslie Ritter, who's testified she heard the victim. It sounded like to her that the victim was running out of the apartment, but that's what she heard. Mr. Goss also heard it. The only real testimony comes is from that confession by Mr. Walker, which is part of the second argument where the court summarily denied that issue. Going back to the issue of prejudice, during that same conference—
Well, how do we know? I mean, in this case, obviously, they went after him, picked him up, and put him in the trunk of the car. So how do we have that testimony in this record?
Through Mr. Walker's interview to Agent Herrera and Agent Hain. That's where that testimony comes from. There's no direct eyewitness testimony as to the blood on the stairwell, the apparent blood stains on the stairwell, the apparent blood stains in the granum, because Lee Ford didn't testify and Joe Gibson didn't testify at this.
But I guess first of all, didn't the defense attorney object to photographs of the blood stains?
What had happened is the apparent evidence had come in the record and appeal on page 1158 to 1160. He at that point said no objection, subject to being tied in. By that time, that evidence was already there in front of the jury. They heard about all these apparent blood stains on the stairwell. And later on, it's the court actually who starts talking about relevance. It's the court who starts talking about and starts questioning the prosecution on, how is this relevant? How is this coming in? And, the prosecutor talks at that point about Mr. Goss having already testified about this. At that point, trial counsel Studstill says, well, Judge, I'm going to move for a mistrial, based on all this evidence that had already come in through Mr. Goss and other witnesses about the apparent blood stains. At that point, the trial court tells the trial counsel Studstill, did you object at that time? He said no. And the trial court says to him specifically, well, it's waived unless it's fundamental error. So he didn't timely object, and it wasn't preserved.
And is that how we treated it on direct appeal?
On direct appeal, this court made a finding that the court hadn't abused its discretion in allowing that evidence in. There was no argument by the state of Florida about the preservation issue.
So I guess so haven't we already ruled that the evidence was relevant? We assumed there was a timely objection. So I'm having a hard time understanding how, if we've already dealt with this and said it was relevant, or it wasn't abuse of discretion, why would you be entitled to an evidentiary hearing to do what?
Judge, we're entitled to the evidentiary hearing to put trial counsel on the stand and ask trial counsel why, or if there was any reasonable trial strategy.
Okay, well, just let's assume that he goes, well, I did object, and we've now, if we decide here that what we said on direct appeal is the fact that it's relevant evidence, then as a matter of law, there's no prejudice, and so it's properly summarily denied. And if you could, I guess you have your other claim, but it just doesn't strike me as that even if he had made the proper objection or whatever, that a judge would have said, no, we're excluding this. And we've already said it was relevant, or that he didn't abuse his discretion.
Right. This court did say that the trial court at the time hadn't abused his discretion. However,
so that's in our case law, though. That's then it's not procedurally barred that you could still claim ineffective, deficient performance, but as far as prejudice, we already really undermining confidence in the outcome. It's legally been established that it was relevant. Am I missing? Am I missing something on at least the second prong?
No, not to the direct appeal, Your Honor. My argument to that is when the prejudice that the prosecutor, without trial counsel preventing him to do so, gets to paint this horrific and gruesome picture of this victim trying to run and escape for his life. He talks about it during that conference. He talks about it during closing arguments about how this man tries to escape and run for his life.
Well, that's what happened.
Right.
Are you saying, do you have experts or something that would say that's not how this crime occurred? Did you put, was that offered at the Huff hearing that we're going to show, we have another expert to explain that how the defendant said this happened? It didn't really happen that way. It happened in some way that isn't horrible and gruesome?
3851 purported to present testimony specifically as to trial counsel in determining whether or not there was reasonable strategy for him not to,
But it has to
that.
mean something. We don't just go through these exercises to say, well, let's go and read the whole trial transcript and say, boy, I would have objected here, I would have done that. We've got to look at it in a real practical sense. What undermines, or what could you possibly say would undermine confidence in the jury's finding of guilt of first-degree murder of the victim? What is the picture that if it was a new trial, because that's what you're saying, there should be an evidentiary hearing, and then the judge would say, oh my goodness, that bloody evidence shouldn't have come in, even though that we said it was okay to come in. Then what? What's the new picture? Do you have anything? Did you offer anything? Did you say that they didn't hire experts that would have challenged this blood evidence, that there was some other theory of the crime that wasn't developed?
Certainly, Judge, there was no evidentiary hearing, and there was no challenge on this evidence because there was no DNA testing done of the blood evidence at the original trial at all.
Did the judge give you an evidentiary hearing on any of the guilt phase issues?
No, Your Honor.
So these were the only two issues that you're bringing before us that you raised?
Right.
Okay.
And if I misspoke, there was the issue of the shackling, but we didn't raise that in our initial brief.
I'm talking going to the defendant's guilt.
Correct,
This
Your Honor.
is it, the blood, and then the confession that they should have brought in the evidence of that he was on drugs before the jury, not just before the judge.
That is correct, Your Honor. And as to the second part of my argument, I would rely on my brief with respect to the fact that the trial counsel failed to argue the involuntariness of the confession by putting on Dr. Bernstein to prove to the jury, in accordance with Florida Standard Jury Instruction 3.9e, that it wasn't voluntary, it wasn't freely done because he was under the influence of drugs, he was sleep deprived, and that was something that trial counsel should have argued to the jury, as the confession was the main piece of evidence in this case to convict Mr. Walker. Thank you, Your Honor.
May it please the court, my name is Barbara Davis. I represent the state of Florida. Unless there's any questions on the guilt phase issues, I'd rely on the trial court order, pages 21 to 22 on the photos, and pages 17 to 19 and 26 on whether defense counsel must present the motion to suppress in front of the jury. And also noting that the trial court found that claim legally insufficient, that it was never alleged in a 3851 that Dr. Bernstein should have testified. It was just generally defense counsel should have done what he had done at a 3-day suppression hearing. And the trial judge found that totally voluntarily. That was an issue on appeal. I would like to go straight to the cross appeal, the state's cross appeal. The trial judge granted the defendant a new penalty phase, and it is the state's position that a de novo review of particularly the prejudice prong will show that he did not apply Strickland properly. At 2 stages of the judge's order, he states, that's pages 4 and 9, 4 and 13, I'm sorry, he states that in assessing prejudice under Strickland, you reweigh the evidence in aggravation against the totality of the mitigation presented during the post-conviction evidentiary hearing. That is not the standard. Strickland sets out, you don't consider anything in a vacuum. Strickland sets out a formula. It's an equation. You have X, Y, Z. And the recent Supreme Court, U.S. Supreme Court cases that the state has cited in the briefs, Wong v. Belmontes and Cullen versus Penholster, sets forth exactly what a trial judge must do. And these cases, both of these cases are very similar to our case. They say, particularly in Wong, the first part of the equation, you must consider all relevant evidence. You start with the mitigating evidence which was presented at the penalty phase and the result thereon. We had mitigation presented, we had an investigation done, there was a 7-5 recommendation.
But I thought one of the problems was that there was not sufficient investigation, that no records, school records and medical records and those kinds of things were in fact investigated and used during the penalty phase.
And there's the vacuum. So if you don't look at, I'm getting to it, that's X. X is you look at the penalty phase. Here's what happened. Then we look at what happened at the evidentiary hearing, and we don't just look at the mitigation that was presented at the evidentiary hearing. You look at Penholster and Wong, and it is all the mitigation, what could be considered mitigation, plus all the cross-examination, opening the door to the negative information. What else came out at that evidentiary hearing that the state could present? As far as what was presented at the evidentiary hearing, which was totally inconsistent with the strategy of humanizing the defendant, here's what we got. We got a defendant who had conduct disorder in school. We have a defendant who was referred to the counseling because he was a juvenile delinquent, and that's why he went to counseling. He was at age 15, he left school and joined a motorcycle game that was bombing and shooting people and making bombs. June Rebert, the little old lady that came in and said from 98 to 2000 he was not doing drugs, he was a wonderful person. Her son was the captain of the motorcycle game who drafted the defendant into this gang. From the age of 15 until this murder happened when he was 33 years old, the witnesses they presented at the evidentiary hearing, Anita Morris hadn't seen him for 18 years. This Mr. Walker was a complete running from the law, in and out of prison, motorcycle gangs, meth dealer, drug addict. We knew a little bit of this in the penalty phase, but the defense counsel at the penalty phase had this sanitized to where Mr. Walker was bipolar, methamphetamines exacerbate that, but look what a nice guy he was. He protected the co-defendant. When he was caught, he was crying. The Good Samaritan came and got him. He was so nice to the Good Samaritan, he saved him. He cooperated with the police. He showed a lot of remorse. That penalty phase strategy got a vote of 7-5. So now what we're going to do in the penalty phase is bring in Mr. Walker, the lost soul, the violent person who beat up the week before this, was beating up Mr. Dioria at the evidentiary hearing. They did methamphetamines, they were speed freaks, but Mr. Dioria stopped hanging around Mr. Walker because Mr. Walker was just beating up people. Mr. Walker, the day before he killed David Hammond, had gone and beat up another person in his meth ring. He was the enforcer. He was the hitman. And then they
So let me ask you, I know you've gone on about a lot about Mr. Walker and his background. Did the trial counsel have this information? And is your argument that with this information, trial counsel made some strategic decision not to put on that kind of information, or is this new information that we are getting at this evidentiary hearing that trial counsel never knew about, never even investigated?
No, here's what trial counsel did, and trial counsel hit a dead end. His strategy, and he had many conversations with the defendant, was to try to save his life. This is just an awful, awful guilt phase case
Ms.
we
Davis,
have. Yes.
Could you answer her question? I think it's an important question.
What he did, yes. So the defendant and
The question was, did the trial attorney have that information that you just told us and made a decision not to use that information? Or is this new information he's now getting at the evidentiary hearing?
The defendant told the trial counsel his past history was not good. His school records were not good. He would not find anything important or humanizing in his school records. He said his school records were awful. He knew about the drugs. He knew about, I'm not sure if it's in the record that he knew about the gangs, but the defendant told the trial counsel about all his sordid past. I mean, that he was in this drug ring, that he was in and out of prison, he was running from the law when he came to Florida.
See, this is the problem, that, first of all, you're making a very good argument, and if after an evidentiary hearing, the trial judge had denied relief, which most often happens, or most often on the other side of this, we'd be saying, well, that's the judge was there, evaluated everything, and made certain decisions. But this judge basically looked and saw that as part of the investigation, as I understand it, he had some phone conversations, and he never sought to obtain any medical, educational, criminal, drug treatment, or social service records. I don't think we have any law that says that when a defendant says, I don't think you'll find anything in my school records, that would be a reason why somebody wouldn't still get the records. Is that what he said? He goes, I didn't get medical, educational, criminal, or social service records because the defendant told me there wouldn't be anything helpful in there?
He did testify to that as to the school records. Now let's focus back on.
But isn't the reality is that the defendant isn't going to necessarily know what's in his school records? I mean,
he knows it's bad.
Pardon?
He knows it's bad.
He knows that he did not behave well in school. But as to what is actually reflected in the school records, the only way you know that is by looking at it. And shouldn't the lawyer go look at those records, even and just to see what's there?
If I may, I would like to focus on prejudice. I do want to answer Judge Quince's question very quickly as to what he did do. He talked extensively to defendant. He talked to the sister who said, can we start with he talked to the defendant. Yes. You're really not before this court saying that's something that he ought to get, like, let's put a point in his column because he talked to his client? No, but he testified that the defendant would not give him information. But if I may, so he had the reports.
Did he hire an investigator?
And brief counsel.
Did he hire an investigator?
No, not for the penalty phase. Okay,
did he have a co-counsel?
He did not.
Okay.
But in Brevard County, they don't. If you look at Wydell Evans.
But it sounds.
Now let's not look.
If you could just calm down for a moment.
Okay.
It just seems to me that what your answer really is that this is not information that the trial attorney had. Can you just tell us that the information that we got at this evidentiary hearing is not information that the trial attorney had when he made his evaluation of what he was going to put on at the penalty phase.
He had the records of brief counseling in his file, and he filed that before the sentencing hearing. That has about the childhood conduct disorder and the counseling at age 15. That was after he was on juvenile probation. And that's the record that they keep saying, well, he had that, he should have explored that further. He had the records from Circles of Care, which showed bipolar. That was after he was arrested. He hired 2 mental health experts to do an evaluation. He called several family members. He looked for friends outside in Brevard County. Now, as far as prejudice, though, let's look and see, okay, what if he had done all that? And that's where the trial judge deviated from the Strickland standard. We have to look at what if he had done all that? What is the result? If we take everything and you look at Penholster and Wong, you look at Wydell Evans, which is another case out of this court, where by presenting these witnesses, you open the door up to so much negative information, so much violence in this defendant's past.
But those cases, and I'm familiar with these cases, usually, and this is a problem when you get to prejudice, when somebody doesn't follow and obtain the information, they can't make a reasonable strategic choice. If they obtain the information, and then you look and say, well, now I decided not to put it on, then you're going to look at prejudice in a different way. Do you disagree with that? In other words, that the first prong has nothing to do with the second prong. That is, that you give the deference to an attorney who has done the reasonable investigation, obtained the information, then says, nope, I'm not going to proceed down this path. I'm proceeding down that path.
And that's exactly what the trial judge did. He kept looking at what counsel didn't do. The mother and the father wouldn't help him, but he should have gotten information from them. The mother and the father, the sister, the family, they weren't at the evidentiary hearing. There was no information at the evidentiary hearing that could have been gleaned from them.
Well, but your main point, if I understand it correctly, is that if he had investigated all this,
yes,
done the investigation to beat all investigations, what he would have found would not have been helpful in obtaining a sentence other than a death sentence for this defendant. It would not. It's not mitigating. It's not, and that what he put on, which was pretty skimpy, but is still better than the reality of this particular individual's life that this information revealed. Is that what you're saying?
That's precisely what I'm saying. Thank you, because. And that's what Strickland says you must do. You must look at everything that was presented at the penalty phase and at the evidentiary hearing and make a determination, okay, now we've got all this. Would that have given us better than 7 to 5?
Where is the evidence in the record that supports that it wouldn't have made no difference?
Well, that's what the trial judge must determine in his prejudice standard, and he did not use the right Strickland analysis, because he said on those pages that he was just looking at the evidentiary hearing testimony, saying, well, if this good stuff had, and he cherry-picked. He was cherry-picking out information. He did not deal with, number one, the negative information, which you have to go X penalty phase, Y what's presented, Z, put it all together. Would what we have now have changed the 7 to 5 recommendation?
So would you, because the judge seems to have done a very thoughtful order, if you're right that what he failed to do is consider some negative evidence, because again, he heard all this, I mean, he thought it was pretty powerful, at least the way he evaluated it, and he's the judge that heard it. Would we send it back to him to say, would you also make sure you look at the negative, or are you saying, no, because we can't, how do we make an independent judgment if the judge hasn't that this negative wouldn't have been helpful.
Well, that's exactly what the court did in Wong and Penholster. You do a de novo review, and you look at everything, and you follow the correct process, which is what was presented at the penalty phase and got a 7-5. Now we have all this baggage here, and everything that would have been exposed in cross-examination, that's Penholster. And then you look at that and you say...
And those are all cases where the defense attorney didn't even know the other good information existed, or they made reasonable strategic choices to keep it out.
And
is that, which one is it, those cases?
They're a little bit different, but the issue is on the prejudice analysis.
If they're different, I'm asking you, are those cases where the defense attorney investigated all the other mitigation and made a strategic decision not to put on witnesses?
I would say no. I would say, because I'm looking at Wong, and it says that in the penalty phase there was mitigation presented and it was substantial. And in Penholster,
Ms. Davis, that's not really responsive. It's a very simple question, and the question was, do those cases involve situations where the lawyer knew of what's allegedly this new information and decided not to use it? It's not a question whether you put on mitigation or not. It's a question that's directed specifically to what has now been presented. Did the lawyer know of that before and as a matter of strategy not use it, or did not have it? That's a very simple, straightforward question.
okay, so in our case, I'm not sure what he knew. In Wong,
Well, we know in
and
this case he didn't have the material, correct?
Oh no, he had the brief counseling that talked about the conduct disorder and the counseling.
Did he have the school records, the social service records? We really need to be able to converse on what the law is and at least agree on the facts, and then we can discuss the law, but we're not even getting the same picture in this case of what the facts are.
Okay, so let's assume he didn't have any of that. Let's assume he didn't have any of that.
Right.
But the independent analysis on prejudice is, if he had all that, would it have made a difference? Would it have shaken the confidence in the outcome?
Okay, and what your basic argument is that when we look at the judge's order, we're going to find that the judge, instead of looking at the whole picture on mitigation, said, well, there was this other good information, but somehow this judge who heard this whole evidentiary hearing and wrote a long order didn't consider what the effect might have been on the bad stuff that would come in. That's your basic argument.
Precisely, and he did not go back and look at what actually did happen at the penalty phase and the result of that and make a determination, is confidence in the outcome changed. Now, he did mention at one point when he was talking about Chris Walker testifying, that Chris Walker testified about the Fates Assembly motorcycle gang where defendant left school. So he did recognize that, but he never weighed it. He never took it all, like Strickland says, and reweighed everything to see if there was confidence in the outcome.
Ms. Davis, you are now down to a minute. Now, I'm going to give you an extra minute because we helped you use that up, but I just... Sure.
No, but I think that Justice Kennedy and Justice Periente phrased my argument just exactly. What I'm trying to say is that aside from the deficiency, if we look at the prejudice and you do the correct Strickland analysis, a de novo review is going to show that that 7-5 recommendation that counsel got, that's as good as it's going to get. Thank you.
The post-conviction court got it right. In fact, in this situation, the Honorable Charles Holcomb was not only the post-conviction court in this case, he was also the trial court judge.
Would you address why is the state not correct? The state is saying to us, take all this information. So what? What you're going to find out, it's even a worse picture than before. That's where the state is going. There's no prejudice here. They had some of the basic information. They presented mitigation. And so what? I mean, so you put some more evidence on. This is not a game on putting on evidence. It is the bottom line. This is the confidence undermined. And that's where the state's going on this. I'd like for you to respond to that.
The confidence is certainly undermined, Your Honor, as the post-conviction court states in the order. First of all, the post-conviction court in its order writes that it does look at the penalty phase evidence. In his order, the post-conviction court talks about Dr. Radden's testimony and Dr. Bernstein's testimony that the court found as being brief and general, and talks about only the bipolar disorder.
So if you could just drill right down to what is actually was presented at the post-conviction, you maintain a substantial difference to a jury hearing all this evidence about this violent background, all of the things that he has done. So what is it specifically, or what are the things that would make a real difference to it?
Certainly, Judge. Mr. Walker's entire life wasn't presented from his childhood until the arrest. First and foremost, Mr. Walker was born to a family where there was extended, long-standing substance abuse, alcohol abuse. Miss Anita Morris, Mr. Christopher...
So we didn't have anything about that at all at the penalty phase?
Correct, Judge. None of his childhood background was presented as to all that substance abuse. There were these children in this house where there were parties and drug parties where, Miss Ruber talks about how Mr. Walker as a toddler could reach up and get the drugs and alcohol off a table, where aunts were encouraging the children to, take drugs. That was very prevalent in his childhood, this continuous and long-standing drug and substance abuse which afflicted Mr. Walker from day one. And of course, it got worse at time. You hear testimony from Mr. Christopher Walker, his cousin, about how the Fates Assembly became involved into Mr. Walker's life. Jeff Reed was one of the individuals who would show up to these parties at the house, which had 30, 40 people, these drug parties. And at the time when Jeff Reed met Walker and took him, per se, under his wing, Mr. Walker was 12 or 13 years old. And Mr. Reed was about 30 years old. He exposes this child to methamphetamines, this drug life, this life of violence where he sees his family beating each other, he sees the motorcycle violence, you see all of this.
And did you have then an expert that put that all together?
Yes.
At the evidentiary hearing?
Yes, Dr. Morton talked about the substance abuse and the effect it would have, considering how prevalent and how, horrific it was, considering he was taking almost 17 grams of methamphetamines at one point. Dr. Morton talked about how it affects a person's, functioning, the paranoia that's very prevalent in Mr. Walker's life.
But what Ms. Davis's argument is, yes, you have that evidence, but it was a two-edged sword. When you put on that evidence, there was going to be all this horrible, terrible evidence that the jury would have heard. Now, what's the horrible, terrible evidence that would have undercut putting this evidence on?
Certainly, Judge, there wasn't anything as horrible and terrible. Mr. Walker was part of this bikers gang, but as I told the court, he got brought in at 12 and 13.
I thought you said the jury knew about that anyway, because did you say at the original trial he mentioned it?
No, Mr. Walker mentioned to Dr. Bernstein about having methamphetamine abuse at the time of the crime, and that's what the sentencing court found.
And Dr. Bernstein was put on.
Yes, Your Honor.
But what you're saying is this judge who evaluated Dr. Bernstein's evidence at trial versus this said it was just cursory testimony, or is it cumulative? Is it cumulative of what you're now trying to put on?
It's very different, Judge. As the post-conviction court cites to Mon, where in that case it's distinguished at the sentencing, at trial phase, the court found mitigation that Mr. Walker was under the influence at the time of the murder. What was presented at post-conviction was the long-standing, uncontroverted, physical abuse, substance abuse, alcohol abuse in Mr. Walker's life. And as this court said...
Was this part of the state makes reference to a history going back to when this defendant was 15, and that information, did that not account for or accommodate that kind of background?
I'm sorry, Your Honor, as in the sentencing hearing or at the post-conviction?
No, the state makes the argument that they had the information with regard to studies and things that were done with regard to this individual by the time he was 15.
Trial counsel did not have that information, Judge. In fact, trial counsel did not even have Mr. Walker sign a release. He didn't have those school records where...
I didn't say school records, that there's no report that goes back to the juvenile kinds of situation they were into. So, I mean, here again, we got two lawyers arguing that facts don't exist. We ought to be talking about the law here rather than either it does or does not. So does it exist or does it not exist?
What trial counsel had in his files that he couldn't even remember at post-conviction was the witness, Edward Gratzig, who was a counselor who was appointed by a juvenile judge. He sent in his records to trial counsel and, asked to be returned. It was never returned to it. It was found in trial counsel's possession in his files, but yet trial counsel never followed up. Never called up Edward Gratzig, never followed up with the juvenile probation officer whose name is in those records, didn't do anything in terms of putting that in front of the jury. He just introduced it, but never did any investigation into it, because that investigation would have released all this information.
And those records and those reports do not, as the state asserts, address this bad background in any way.
It does talk about, the...
So it does have something to do with the bad background. And the lawyer did have that.
It only had to do with respect to what Mr. Gratzig talks about, the substance abuse, and also what he was trying to do to help this child.
You stood there 15 minutes telling us about the methamphetamines he's taking. Is that not drug abuse?
It is, Judge, but it was never presented to the jury in the sense of how bad it was, how long-standing it was.
Well, now that's something that's totally different. I mean, you can always maybe find a better witness. The question is, was that information available? Was it used? Was it and you're saying that report was used with regard to this trial, the underlying trial.
It was just entered into evidence, but...
Well, I mean, that's what you do. Lawyers enter evidence. That's what we do. So it was entered. It's just not the same way as you wanted it presented through post-conviction. Is that a fair statement?
Yes, Your Honor, it was entered. However, when Edward Gratzig takes the stand at post-conviction, he gives it, he gives it more of the background. He talks more about,
So you found witnesses to elaborate on what was presented during the trial.
And that witness was always there, Judge. That witness was always there.
Well, I understand that, but again, that's what this case is about. It's not about new information. It's about elaborating upon and expanding upon that which was already before the jury through the form of these records that were placed in evidence.
In this case, Your Honor, yes, I agree with the court, but this case is also about failure to investigate evidence that was always there and readily available to trial counsel. I mean, the strategy of, humanizing Mr. Walker, that wasn't the strategy by trial counsel. It was, in fact, part of it, and the post-conviction court recognizes, was to show that the victim was a bad person. Yes, he talks about it's important, but he didn't do anything. 5 short phone calls, 175 hours of work for the entire case. This was his client's life on life. He didn't even get basic mitigation records. None of that, Judge. He didn't do any investigation.
So how did the record, I just want to make sure I understand. There's some record that was entered into evidence. It's the evidence, it's the record that Ms. Davis is saying now would have contained some bad stuff about the defendant?
It talks about, this young child who Mr. Gratzig was his counselor, and he tried to help him, but he couldn't. But, what happened with respect to the system and how it failed.
But the defense lawyer puts it in evidence, but does nothing with it to argue to the jury?
Nothing with it, Judge. That would be my argument, Judge, that Mr. Studstill didn't do anything short of those few phone calls. And Dr. Bernstein's the one who got the records. He didn't even have a release sign. He didn't get any of those records, Your Honor, to save his client's life.
Did this report just miraculously go into evidence? There wasn't a witness?
It was introduced by trial counsel Studstill, Your Honor.
Well, I understand, but through a witness, documents just don't fly into evidence.
Oh, through Dr. Bernstein, Judge. Dr. Bernstein's the one who
So there were, these records were placed into evidence through a witness, and did the witness discuss, were questions asked about this report?
Not specifically, Judge. If my memory calls, Dr. Bernstein talks about there being evidence in records about substance abuse, but Dr. Bernstein's main function at that penalty phase was talking about bipolar disorder and him being under the influence of drug abuse and sleep deprivation at the time of the crime, not about, you know, the long-standing drug abuse, which is very, very, you know.
But that was in the report that he relied on.
The long-standing drug abuse,
Right.
Judge, not to the extent that it was presented at the
I didn't say
post-conviction.
to the extent. We're qualifying words. I mean, lawyers play these word games. Was it in the report? That's a very simple, straightforward
Just
question.
yes, but only for that brief moment in
Okay.
time, when he was under the care of his juvenile probation officer and Mr. Gratzik.
If you could sum up your.
Judge, the post-conviction court is correct. There was competent substantial evidence for the post-conviction court to make its findings in this record appeal. And of course, this court recognized that we need to give great deference to the findings of the post-conviction court. His conclusions, based on Wiggins, Mon, Pierce, and the other case law cited, supports his position that you know, Mr. Walker should be granted a new penalty phase because his trial counsel didn't do anything in terms of mitigation evidence that was reasonable, meaningful, and no strategy can overcome that when the basic mitigation of investigation was almost nothing. It asked the court to affirm the new penalty phase decision by the post-conviction court and afford Mr. Walker a new trial based on the guilt phase issues. Thank you, Your Honor.
Just briefly, I would note that the sentencing order is attached to the state's answer brief. And if you look at that sentencing order that was originally entered after the penalty phase, you will see that the judge addressed the serious bipolar disorder, counseling when he was 15 years old, that people affected with bipolar disorder tend to self-medicate with alcohol, cocaine, and methamphetamines. Dr. Bernstein testified to this. Dr. Radin testified to this. The use of those controlled substances over a period of time exacerbates bipolar disorder.
Where did they get Dr. Radin and Dr. Bernstein? Were they people that treated him in jail?
One of them,
were they the counsel's own mental health experts?
one was hired and one was the jail psychologist, and with circles of care. And I can't remember which one was which.
So I guess your argument on whether we go to the deficiency or less prejudice, you were saying that this stuff would have resulted in all this bad information, but if the circle of care record came in, did it come into evidence?
There's two separate records we're talking about. There's the circles of care in Dr. Radin, and then there's the Center for Brief Counseling, which is when he was younger, the Edward Gratzik records.
And which ones did the counsel have?
Both.
And which ones went into evidence?
Both. Now,
but I thought you said those are the ones that would have contained all this bad stuff that the state could have used to argue against the good stuff.
that's what I need to clarify. The circles of care records went in at the penalty phase. The brief counseling, the Dr. Gratzik records, which is when he was younger with the conduct disorder and all that, came in on November 15th, which was between the Spencer hearing and the sentencing hearing. And those were filed with the judge only. And the judge in the sentencing order did address those records.
So the state could have, you know what, well, I guess we're going to have to look at this record, because I'm thinking, well, if they came in, then the state could have argued all the bad things in the record, and so that kind of way undercuts, well, that's why the defense lawyer didn't put them in, because they would have been prejudicial. If he put them in, then, and the state didn't argue it, then it paints a different picture here, that the state really didn't have anything to counter these records with.
No, we're talking in front of the jury. If these records came in the jury, which trial counsel gave them to the judge, This would expose the defendant, and it's not just those records. When he was 15, it's when he was 15, he became a real criminal. He was in prison for 3.5 years. Then he's on parole, and he escaped. And
that didn't come before the jury?
Never. No. And I'd also like to point out the case of Wydell Evans. It's cited in my brief. Almost exact same scenario. It says that when you display this and the escalating pattern of violence, which is exactly what we have here. He has a long criminal history, and then suddenly he escalates. He's got this meth dealer business. He's got this head of steam, and he starts beating people up, and he ends up killing Mr. Hammond.
You're well into overtime. If you kind of sum up now.
And just point out that in weighing this, remember the aggravating circumstances: heinous, atrocious, this brutal torture, beating, shot in the face, abducted, carried to a remote area, cold calculated, premeditated, and then the kidnap of the 2 girls. Thank you very much.
We thank you both for your arguments. The next case on our docket today is King versus the state of Florida. Counsel, you may proceed.
May it please the court, I'm Steve Bolatin from the Public Defender's Office in Bartow. I represent the appellant Michael King. Time permitting, I'm going to argue the first 3 points on appeal dealing with Robert Salvador and the ballistics comparison. If time doesn't permit, I'll rely on the briefs for those issues. Robert Salvador was a key state witness in this trial and a key figure in appellant's theory of defense. He was initially a suspect in this murder, but the police quickly dropped him as a suspect after Michael King's arrest. Even though Robert Salvador had been evasive and made inconsistent statements concerning his whereabouts and his interactions with King. After Salvador testified on behalf of the state about his activities at the gun range earlier on the day in question, defense counsel cross-examined Salvador regarding his own possible involvement in the murder.
That's sort of an understatement.
Yeah, it is an understatement. Yeah. I mean, it was accusatory questioning, yes. Yeah. And then this was done without objection by the state. There was a series of approximately 6 questions asked and answered. No objection was made by the state. Subsequently, one of the prosecutors, Ms. O'Donnell, gets up and does redirect of Salvador and goes over some of the same ground, gets him to reiterate his denial of any involvement. After Salvador was finished testifying, after he had stepped down from the stand, the other prosecutor, Mr. Arend, approached the bench and expressed his grave concern over what had just happened in the courtroom. And what was going on is Mr. Arend had a grave concern, but he withheld his objection. He did not contemporaneously...
should we decide this case on a waiver procedural basis, or do we approach the substance?
I think you approach the substance. Okay, I think this is not a case where the state it's not a state appeal that the state waived by failing to object. Okay. This has to do with an entire sequence of events.
Let's talk about the law.
Right.
Is a court, trial judge authorized to become involved where there is presented through a question fabricated evidence that doesn't exist?
I would take issue with this being fabricated evidence that doesn't exist. This was questions.
No evidence. Was there? Well, okay.
Well,
help me
the first question.
Where is the evidence that this Mr. Salvador did the shooting?
Well, there is circumstantial evidence throughout the case that indicates that Mr. Salvador might have done it. We don't have to show proof beyond a reasonable doubt or even proof sufficient to go to a jury.
You have to have a good faith basis.
We have to have only, right, defense counsel had only to have a good faith basis for asking the questions.
And we would determine from looking at the evidence that was presented, Mr. Salvador, the gun range, where he was and what the evidence would indicate where he was at the time of the alleged shooting, and we would determine that there's not a good faith basis for these accusations being made to a witness in a courtroom before a jury, then the law of Florida would be is that, yes, we can affirm a trial judge's excluding of that evidence.
Well, except that a great deal went on beyond that.
I'm just saying, let's go through that step. Okay, so then you're saying it's beyond that, so let's go to that.
Right. Well, the first thing, I mean, there's a lot of different things, and I don't want to be all over the map here, but the first argument I have to make is that there clearly was a good faith basis for the questioning, and that's all defense counsel had to show.
And what's it based on?
What it's based on is this. I mean, first of all, well, I mean, before getting into the circumstantial evidence, I mean, the prosecutor, Aaron, kept running up and down saying, well, the jury's going to think he got this information from his client. The jury's going to think he got this information from his client. Well, it may very well be that he did. He wasn't able to, I mean, defense counsel didn't say, I got it from King, because the trial judge specifically said, I don't want to hear that. I don't want to touch that with a 10-foot pole. I don't want to go there into privileged communications. But the prosecutor was certain he got it from the client. If he did get it from the client, that would be a good faith basis for the questioning right there, and I'd cite Skull versus United States for that. But in addition to that, looking at the circumstantial evidence in the case, you have Salvador's initial status as a suspect. You have Salvador's evasiveness about his whereabouts, withholding of information, inconsistent statements. There's even a representation at a subsequent Richardson hearing where this comes up later in the situation where they're on the motion for, I believe it was at the time of the motion for mistrial, and there was a Richardson hearing having to do with the late disclosure of Salvador's wife as a potential alibi witness, and defense counsel represented that Salvador had failed the polygraph.
You know, I am a little bit concerned about why even Mr. Salvador was a suspect from the beginning, because as I read all of this, it seems to me that we have a lot of evidence of people who saw this Camaro, wasn't it? And describing the person who was in the Camaro. And from my understanding, Mr. Salvador doesn't look anything like Mr.
It was Mr. King in the Camaro.
King.
It was. I'll address that concern because I have conceded that any error in this case is harmless as to the kidnapping and the sexual battery. There's no question that that was King in the car with the victim in the case. There's no question that the victim was in King's house. There's no question about the DNA evidence.
No,
there is absolutely
that it was
overwhelming.
His voice on the
absolutely, it was King that that the witnesses, Ms. Kowalski and Shane Johnson, I think his name was. Absolutely, that was King. The evidence is absolutely overwhelming in this case as to the kidnapping and as to the sexual battery.
Here's the thing, and you were an excellent attorney, and you are always prepared, and you're always willing to concede things. Let's just take that the judge allowed them to cross-examine Salvador and say, Mrs. Salvador, didn't you fire the shot that killed and took the life of Denise Lee? She could, absolutely not. So the jury, he was able to ask the ultimate question, did you shoot her? Now, the cross-examination, didn't you go to the house and wasn't the purpose? If it's in or out, how do you get to a situation where a jury is going to believe that after a defendant kidnaps, rapes, and terrorizes a victim for over hours in just, as you would agree, the most horrendous, the 911 call, everything, that somehow he needed help from a friend to shoot her?
He didn't need help from the friend, but it may be.
Are you saying Salvador, it was the theory that Salvador was with him the whole time?
No, absolutely. No, the theory was that, Salvador didn't materialize at the scene, which is what defense counsel was forced to argue. The argument is that Salvador was in on this from the beginning, but was not participating
and where would the jury get that? Okay. And what is and somehow, again, to carry out this horrible scheme, he didn't have the ability to shoot the victim?
He had the ability to do it.
It's preposterous.
It
Anyway, I mean, it's whether he should have been
all right.
allowed to cross-examine. It's a preposterous theory.
I have to take issue with it being a preposterous theory under the particular circumstances of this case. First of all, we know, if you can believe, I mean, taking at face value the testimony of the FDLE gunshot examiner Romeo, we have a pretty good idea that the victim was shot with Salvador's ammunition. We know that Salvador had a 9mm firearm, which he was using at the firing range, which the state had in its possession and never bothered to run ballistics tests on that.
And did that all come into evidence?
Yeah.
Okay, so in other words, so it was, you had a basis to say it was Salvador's ammunition, which of course was explained by the fact that he says that this defendant must have taken the ammunition. I don't see, maybe I'll try to give us on this point. First of all, as Justice Lewis was asking you, where's the basis, a good faith basis for asking those three questions? If there isn't one, or even if there is, what I'd ask you, where is the harm in the judge saying to disregard these three questions when you had no other evidence to put in to actually substantiate it?
I have to answer probably, about 6 questions, and I'm going to try to do that. But the harm, first of all, the judge didn't merely say disregard those questions and answers after the state didn't object to them for tactical reasons. The judge was, the prosecutor wasn't okay with that. The prosecutor says, you got to do more. You got to tell the jury that there is no basis in fact or in the evidence or inference from the evidence for the asking of these questions, making defense counsel look bad. Worse than if he had never asked the questions in the first place. It's a comment on the evidence, which is strictly forbidden under Florida law. But again, going back, I think it's important to address.
It's not a comment on the evidence. Well, it's the question. It's a comment that there's no basis in this courtroom to ask that question.
Again, I think there is. I think, first of all, like I say, if he got the information from his client, that would be a basis. And the fact that he had information or represented...
The standard here we're dealing with is what? Abuse of discretion?
I believe that, it would. I think it would be an abuse of discretion. And I'm going to. The gun is very important here. Okay. First of all, Salvador didn't say that King probably took my ammunition when I wasn't looking. He allowed us how that was possible, but he believed that King didn't have any ammunition when he left the gun range.
Your argument about if he got the information from his from the client, if the counsel got it from the client, then that per se is a reasonable. Or good faith basis.
That plays in with other factors to create a good faith basis, yes.
Okay, so you've got to look at the whole context of
right.
but the part of the problem is we don't know that happened. That's all speculative.
Well, again, all counsel needs is a good faith basis, and it doesn't even need to be based on admissible evidence. If he knew, as he represented, that Salvador had failed a polygraph, that plays into a good faith basis. But I think the most important thing is the gun. Most important thing is the gun, because King was arrested very shortly after this would have occurred. And most of the evidence, the body is found, the clothing is found, King is like wet and disheveled. There's all this evidence found in the car. There's all this evidence found in the house. If he made any effort to dispose of evidence, he sure wasn't very good at it. But in the meantime, over 2 years, or nearly 2 years of investigation, they never found the supposed 9mm gun that, according to only Robert Salvador, King had. That's the only evidence that King ever had a 9mm, was Robert Salvador says so. But we know Robert Salvador had a 9mm, and it wasn't tested. Okay, if King had a gun, where is it? They were looking for it for 2 years. They went at the site of his arrest. They combed the grassy area up to the tree line, back and forth through the exit. Any place that a gun could conceivably have been thrown, they didn't find it. They didn't find it at the burial site. They didn't find it at the clothing site. They didn't find it in or near King's home. They dredged lakes, retention ponds, the sewers. They looked up and down for this gun, and they never found the gun. That may well be. I have a good faith basis to believe, from defense counsel's vantage point, King never had a gun. Salvador had a gun. Salvador's gun was in the possession of the police. They could have tested it when they were having Romeo do his little comparison of eyeballing in a microscope these two cartridge cases. They never asked him to even look at Salvador's gun because they were satisfied with Salvador's alibi. Well, what was Salvador's alibi? This goes into good faith basis as well. Salvador
also,
on the
can't they look at what the evidence is?
What?
They're not allowed to look at what the evidence is. I mean, my goodness. I mean, the neighbor sees this vehicle.
Sure, they're allowed.
And this defendant avoids a witness on the roadway who's trying to hang back.
They are absolutely allowed to look at what the evidence is. There's no question that King is guilty of serious crimes here. He's guilty of kidnapping. He's guilty of sexual battery. He would be guilty of murder, but for the fact of the instructions that the state chose, for reasons I hope I get a chance to get into, to have the jury instructed. He was not guilty of murder under the instructions in this case. But if the state had requested a principal's instruction on either premeditated murder or felony murder, this wouldn't have even been a defense. The state chose to make it a defense. This was presented to the jury. You can't convict King of premeditated murder or felony murder unless you find that he was personally responsible for the shooting. That was in both parties' closing arguments. Why would Mr. Aaron, an experienced prosecutor, not ask for a principal's instruction or a standard felony murder instruction that you don't have to be the triggerman?
Help me understand your theory of Mr. Salvador's involvement. You said he was in on this from the beginning. Well, what's this? I mean, obviously the end result is this horrific murder. But what was the theory of his involvement? He's just to show up there to administer the shot that killed the victim?
The only other possibility I can think of. I mean,
But what possibility? I mean, that just strains.
It
credulity.
does strain, but...
Well, if it strains credulity, how can it be a good faith basis for all this?
Wait a minute. Now, the argument is that that Salvador may have been in on this from the beginning, and there's circumstantial evidence that does tend to support that, and there's his evasiveness and inconsistency.
I guess, I read through this thing now. Now, this guy is driving up and down the street 3 and 4 times. And, I mean, how did Salvador know who this person was, where he was going to stop? I mean, was there phone records or something? He called Salvador and told him that?
Salvador deleted all phone calls that he received from King on that day.
What about King's phone?
There's no evidence, dealing with that. But I do. All right. I really regret going here, but I do have to say this because you say what could possibly have Salvador's motive have been? Why? I mean, speculate on that. Did he? The prosecutor ridiculed it in closing argument after defense was precluded from arguing it. The prosecutor says, "Well, I just always wanted to shoot somebody. Sure, Mike, I'll help you out." And then Mike is saying, "Well, I'll rape you, I'll kidnap you, but I draw the line at murder. I'm not that bad a man."
Okay, in fairness, and I said it was preposterous. You said that's going too far. It is, I think, what we're struggling with here, and this goes back, we're just on the first point about these 3 questions, is that not only does it appear to be a good faith basis to have asked the questions, but even if you say, well, he didn't have the gun and Salvador had a gun, the idea that, and Justice Perry's asking you this way, and Justice Kennedy, that somehow they're going to pick he's picking someone up at random. There's no communication. All these horrendous things happen over a period of several hours, and somehow he's communicating how to Salvador to show up at the last place with the gun so he could shoot him? That's what we're struggling with.
Number one, he may have communicated it to him at the gun range. That was one of the questions asked. But I have to go here, and I regret having to do this, but as long as you're asking what could possibly have been Salvador's motivation could have been the same as King's motivation. I mean, we know from the physical evidence, the medical examiner testified that there was evidence of sexual assault, both vaginally and anally, and that it was inconsistent with any sort of consensual sex. We know that King's DNA was found in semen in the vaginal sample, but we also know that no biological fluids were found in the anal sample, which raises the possibility that Salvador's motivation for his involvement in this could have been the same as King's. In other words,
but there's absolutely no physical evidence connecting Salvador to the crime scene or any of these places where the victim was. Isn't that correct?
That's correct.
Furthermore, wasn't there video evidence to show that he was some other place while all this was going on?
Actually, no.
I'm not talking about the shooting, but I mean the assaults.
That's a point that I would like to get into. There was the police officer, the lead detective Morales, when he was asked, well, why did you drop Salvador so quickly as a suspect? Well, basically, we believed his alibi. Well, what was that? He had a receipt from Checkers, and there was a video from Home Depot in Venice, both around the period of 3:30 or 4 in the afternoon. According to Salvador, Salvador kept expanding on what he had done during the afternoon, but under any one of these versions, he arrived home around 5:30 or 6, according to him. The murder clearly happened after 6:14 because that's when
I'm talking about the assault.
Well, no, I'm saying an assault could have occurred.
You said he was part of the
I'm
rape.
saying no, it didn't occur in King's house, though. If Salvador was part of the assault, it occurred at Panacea and Plantation between 6 and 9. In other words, if Justice Periani is saying, why on God's green earth would Salvador come out here just to shoot this shot? And I'm suggesting a possible reason that is consistent under the evidence, which would be that a sexual assault occurred.
But they didn't even in the cross-examination that went too far, they didn't say, and I mean, why didn't he say, Mr. Salvador, didn't you also rape the victim as well? I mean, if you're going to, you're telling me that was a theory that the defense advanced at trial?
No, I'm saying that that's my response to your question about saying that it's preposterous that Salvador could have had anything to do with this.
We're really here to see if the guilt phase was fair or whether there are errors that require reversal.
Correct.
So you may want to, what I think you're hearing from Lisa's first point is that if there's no good faith basis that we can discern in this record, and it wasn't offered, then there was no error in what the judge did. Further, from my point of view, even if he had been allowed to ask those questions, it's like asking a question and not having evidence to support it isn't going to get you very far.
Well, I'm going to beat a dead horse here a little bit more, though, because number one, I think that there's a real double standard going on as far as the states trying to seize a tactical advantage. They could have, this whole problem would have gone away under your theory, assuming that the judge could have sustained an objection. They should have objected then. They shouldn't have waited.
Well, there's no waiver in the trial court. That's for an appellate.
I understand, but it got worse than that.
But I mean, this is like to try a defense lawyer forcing the opposition to jump up and start objecting to stuff so it looks like the state's trying to hide something. I mean, come on, you're a seasoned lawyer. This cuts both ways. Your argument cuts exactly the opposite way as well.
I'm not sure I understand.
Well, so what does the state supposed to do? Stand up and scream and beat on the table? That's an improper question.
No.
And so the objection signals to the jury that the state's trying to hide this line of questioning.
We have that same problem all the time when we're expected to object to stuff. I mean, that's why old-style defense attorneys used to say, I never object to things, because the jury's going to hold it against me, but at some point, if you want to preserve...
Your argument is it made the defense lawyer look bad.
No,
that was your argument?
What made the defense lawyer look bad, in particular, was a couple of things that occurred later during this entire sequence of events. And I think, getting back to the question of harmless error, this isn't one thing that happened. This is something... And it wasn't inadvertent. This is something that pervaded the trial. And I'm going to play the This Is America card. Everybody gets one fair trial, and I don't think this was it. Even if you don't like the defense, you get to present your defense, and he didn't get to. It was torpedoed. It was eviscerated. when the judge basically said, okay, well, what's the remedy here if I think there's no good faith basis? I instruct the jury to disregard it. State's up, no, that's not good enough. You got to tell them that it was improper and it was no basis in fact and no evidence or inference from the evidence. So then he does that. Then in closing argument, the defense is told, well, you can argue that Salvador somehow materialized, but you can't argue any of this other stuff. Defense lawyer is reluctantly saying, well, I understand your ruling, Your Honor. And what does the prosecutor do? He gets up in his closing argument. First thing he says is that comparing it with the victim, talking about the day of the murder being the last day, the worst day in the victim's life. He then says, and last Wednesday was the worst day in Rob Salvador's life. Makes the defense look like he's persecuting poor Rob Salvador. Okay, then the prosecutor ridicules the defense. The defense attorney was told, you can't argue this. You can't argue that there was any agreement. And then the prosecutor rips the very thing that he can't argue apart. Then he attempts to shift the burden of proof by saying, the defense said in their opening argument that the evidence would show that someone other than Michael King fired the fatal shot. Well, ask them for that evidence. A clear comment on silence. There was an objection. There's a motion for mistrial. It was denied. And I think basically the problem here, this is hard cases make bad law. This is a hard case, but this is not a single error. This is just the way, and again, on the harmlessness question, Mr. Aaron clearly didn't think this wouldn't have mattered. If he thought it wouldn't have mattered, he wouldn't have conducted himself the way he did. He clearly, I do need to get back to the important thing here. Why would Mr. Aaron not have requested a principal's instruction on premeditated murder or felony murder? Talk about a seasoned attorney, he knows about that. The reason he didn't is because he didn't want his penalty phase muddied up with any questions about Robert Salvador. He wanted to take the position Robert Salvador had nothing to do with this. So I don't want you
I'm
even
missing something. Somehow the state, by holding itself to a higher burden, somehow has created error here.
No, I don't think
this.
I don't think they created error by holding it. I think there was a reason why they chose to hold themselves to a higher burden, and that reason showed that they were concerned about this. This was not something that they thought wouldn't have made any difference. If they thought it wouldn't have made any difference, why do all the things they did? Why fight so hard to say it's not enough to just instruct them to disregard? You have to tell them this was completely bogus? Why do the things he did in closing argument? Okay, if I have any time left...
You're now down to about 5.5 minutes. So you're into your rebuttal.
I'm into my rebuttal?
Yes.
You've
got a total of about 5.5 minutes.
I think I better use that then. I better use that on the other issues real quickly. The firearms examiner, Romeo, compared 3 cartridge cases from the gun range with a cartridge case found in the brush in the area where the burial site was. And ordinarily, this would be the kind of thing, okay, you show a defendant's connection with a fatal, with a bullet that you know was used in the crime by showing that it matches a bullet that he was known to have fired or a gun that he was known to have possessed or something like that. In this case, we have circular reasoning because we don't have either of those two things. We have a cartridge case, and no projectile was recovered, but a cartridge case was recovered.
We know he fired at the firing range.
We know what Robert Salvador says. I will concede that he fired some shots at a firing range, as did Robert Salvador.
Well, then really, that wouldn't be that prejudicial because it could support that it was Robert Salvador that shot him just as much as it supports King.
Well, 2 things on that. First of all, the bullets that were recovered weren't connected to Salvador or King. I mean, they could have been literally dozens of people that fired them. There were thousands of bullets. Salvador didn't even specifically remember which range he was at.
Range?
There were thousands of...
Salvador, though, showed the detective which ones were theirs.
No. Salvador, first of all...
He didn't go back out with the detective?
He went back out with the detective. He didn't know which one. What Salvador did, first of all, Salvador didn't even remember whether they were at the 10-foot range or the 25-foot range. He goes out there. He testifies that there's literally thousands of bullets in the vicinity. What they were doing is they were picking up every 9mm bullet they could find. Salvador can't identify this is my 9mm as opposed to some other guy's 9mm.
Well, you can't just take this in some kind of isolation. We have at the scene of an awful circumstance a casing. There it is. Are there any other casings somewhere else that match this? Oh, yes, there were. There were at this location, and we connect the two together. I'm missing why. I mean, you're saying that this can't come into evidence at all, and I mean, I'm missing that. I mean, I've got a piece of evidence, and if I can trace it back to where the defendant was firing weapons, that is some evidence that connect those two events, it seems to me. If I've got an expert that says this casing matches casings that were found at location A.
Well, first of all, we're claiming the expert's testimony was inadmissible for reasons that I'm not going to have time to get into.
I understand.
But, okay, first of all, the casing that was found at the crime scene was, I mean, is it possible that that was from the shot that killed the victim? Sure. But on the other hand, this is an abandoned construction site. There's no projectile recovered. I mean, that casing could have been there for...
Well, what are the inferences to be drawn? Just a casing that happens to be where this awful scene is, and wow, we happen to have a same casing and where this person was earlier that day, firing weapons. And you're saying that that's not an inference or a circumstance from which a jury can connect those two sites?
Even if it is, then let's get back to Justice Pariente's question, which is, it still would be just as consistent with Robert Salvador as with King.
But that's for you could argue that.
Right.
It doesn't affect the admissibility of the evidence.
What it does though, I mean, if you're saying that this, you know, any error was harmless or that it wasn't significant or that it wasn't error.
No, there was no error.
There was no error because it was just as consistent with Salvador. That, again, I mean, if you're going to hold that, then that goes back to the first issue, which is why the evisceration of the Salvador defense was so harmful.
I didn't say it was just as consistent. I was saying that a defense lawyer could argue that it was Salvador that left those bullets.
Well,
I didn't say I think it's as consistent.
I don't see any way that it could be less consistent with Salvador since we know those were his bullets. I mean, you know, Salvador thought that King didn't have any ammunition when he left the gun range. He allowed us out. It's conceivable that King could have pocketed something.
Because of all that, it's connected to the defendant because of all this other evidence that physically connects the defendant to these crimes, and the total absence of any physical evidence that connects Mr. Salvador to the crime. Well, I mean, that's why it's more reasonable.
Again, I have to concede that
overwhelmingly more reasonable.
There is no physical evidence that ties Salvador to the crimes, but there's a considerable amount of circumstantial evidence that suggests that he could have been involved. And I think that that was prejudicial not only as to the guilt phase, but certainly as to the penalty phase. Because if the jury had found that Salvador was or could have been involved and he was walking off scot-free, that could very easily have made them less inclined to vote for a death recommendation. I'll reserve the rest of my time for rebuttal.
Okay, and I'll give you a couple of extra minutes too. Yeah.
Good morning, Scott Brown on behalf of the state. The defense counsel in this case far exceeded the proper bounds of cross-examination when he asked very specific questions of witness Salvador, which inserted specific facts for which counsel had absolutely no good faith basis. I would argue there was no basis articulated below, good faith or otherwise. Defense counsel was repeatedly pressed by the trial judge. I don't see the basis for these questions. Where did you get those facts? Defense counsel said, well, Salvador repeatedly denied them. Is the witness's denial a good faith basis? No. He did not even point to a hearsay, double hearsay, triple hearsay statement, out-of-court discovery, anything to support those facts contained in those questions.
And the facts being that after they left the shooting range, that he had arranged to come back to the house.
Correct, and bring specific items, the lawnmower and the gas can, and that he agreed to later on meet him on Plantation Boulevard.
But the judge allowed the question, didn't you shoot the defendant? I mean, the victim. Your Honor. Based on the fact that, was the good faith basis for that these, the bullet casings at the range matched what was found at the scene?
You know, that's a supposition. I would contend that the judge gave considerable leeway to the defense because he could have very well, I would contend that there were 4 improper questions. The question that defense counsel was allowed to ask Mr. Salvador, and wasn't it you that shot the victim, Denise Collins? There is absolutely no evidence, physical, not an evidence, none linking Mr. Salvador to
Well, I
this crime
guess it would be
whatsoever.
this way, which is, and it's, I call it preposterous, but as far as the evidence of the comparison of the tool marks, since we know that they were both shooting at the range, then whoever, it could have been either of their bullet casings, and since it was Salvador's bullet, it's his bullet at the, it was his bullet at the scene. That doesn't mean he's at the scene, but it seems to me that that is at least a good faith basis to ask, aren't you the one that shot the victim? So, I mean, and that's for the same reason. I don't think that this bullet casing thing is all that, it just says whoever was shooting at the range is most likely the one that shot the victim, right? And it's
well, let's go back to
am I wrong about that? In other words, it doesn't. I mean, in a way, it does. It is likely that or probable or highly probable the shooter was the defendant. But
absolutely, Your Honor.
The comparison of the bullets simply says whoever was shooting at the range using those bullets is the same person that shot the victim at that construction site.
Agreed. I guess I don't see the good faith basis because there was no evidence aside from Detective Morales, who testified that he looked into King's alibi and he had a receipt for 4 o'clock at Checkers that panned out. He looked at a videotape. Now, that's the evidence that came from the witness stand, and we're talking about 3 questions that were disallowed in this case. And the judge instructing the jury, redundantly, the state contends, that there was no evidence to support those questions. And with or without that instruction, the jury's going to know that there was no evidence to support those facts. So, again, Mr. Bolatin's very good at making a mountain into a molehill, but we don't even have an anthill here.
What about his argument that the prosecutor
Or a
using...
molehill into a mountain.
Yeah, I think you got that.
I don't even think we get to molehill here, Your Honor.
address his argument that the prosecutor used argument in closing that the defendant's attorney couldn't respond to.
Well, I disagree. There was no argument, and from this record, there's absolutely no proffer of any argument defense counsel would have made other than the one he did. And again, he tried to shift suspicion to Mr. Salvador, and there was no improper argument in this case. What the defense did in this case is they didn't, in opening statement, come right out and accuse Mr. Salvador of murder. They said the evidence will show that someone other than Mr. King fired the fatal shot that killed Denise Lee. The prosecutor got up and said, okay, you've heard all the evidence. Is there any evidence other than the fact that Mr. King fired that fatal shot? So I think that was a legitimate comment on the evidence. And again, Mr. Bolatin is contending that there was some kind of handcuffing of the defense. I think very charitably, the defense was allowed to pursue an implausible, unrealistic theory without any evidence that Mr. Salvador may have shot the victim coming in at the last moment. And then when the state tried to present Salvador's wife to thoroughly rebut that theory, the defense jumped up and down and said discovery violation. So what Mr. King had the benefit here of is completely arguing a theory without any evidence to support it, and then preventing the state from conclusively rebutting that evidence by bringing in Mr. Salvador's wife, because we know that Mr. Salvador was home between 5:30 and 6, and he was awakened at 2 o'clock in the morning that very evening. And again, if I can just go back to the evidence here, this is not a case where the defense was crippled by the restriction on cross-examination. What crippled the defense in this case, and not unfairly, was the overwhelming evidence showing that King kidnapped, raped, and murdered Denise Lee.
Let me ask you, I'm just curious, how was it that Mr. King chose Denise Lee in this case? Had he seen her someplace else before, or was he just cruising through the neighborhood to see if he can find a victim?
That's a very good question, Your Honor. I did not see anything in the record. And we know that Mr. King worked as a plumber, and again, he might have targeted her previously, and we just don't have that evidence. But we know he circled the neighborhood in his distinctive dark green Camaro. He was seen alone in that neighborhood, and he pulled up in the driveway, and he abducted her. Again, he's all alone at that time. And then we know that there's an unbroken chain of circumstances, both eyewitness and forensic, showing what happened to Denise Lee. She was taken back to his house where her DNA, to the exclusion of, I think it's 1 in 3.5 trillion. Her hair is on duct tape in Mr. King's kitchen. Her blood is in his master bedroom. And we know this from DNA evidence. Mr. King's DNA to 1 in 1.5 quadrillion, it's a 1 followed by 15 zeros. His semen is in her vagina when she is found buried in a 4-foot grave. Her blood is on his car. Her wedding ring is in his car.
Let me ask you this, because there's, in my mind, a little sequence of events I'm not really sure of. He abducted her in the afternoon.
Correct, Your Honor.
2 or 3 o'clock in the afternoon, somewhere around there.
Between 1 and 2:30.
And when was the last time, first of all, when did the medical examiner put the time of death?
That evening, January 17th, to the early morning.
Of the day.
Well, we know they could only narrow it down a certain amount, but we know she was alive because Jane Kowalski saw Mr. King in the Camaro at about 9:14. Excuse me, 6:4. Excuse me, I'm getting that wrong. He was pulled over at 9:15. 6:15, we know she's still alive. He's driving her to the burial site off of Plantation. She's screaming for help, and she tries to get in back of the car. So the
last time he was actually seen was at 6:15, around that time.
Around 6:15 in the evening.
And so the medical examiner has put the time of death somewhere between 6 and 9 o'clock?
I don't think he could be that precise, but we know that's the logical sequence. It was that evening. I mean, she was clearly buried. Mr. King was pulled over about 9:15, so he had 3 hours to dispose of her body. And we know that her blood's all over his car. Her hair is on his hood.
But we don't actually know where the murder took place, whether it was at his house or at the gravesite.
The blood evidence suggests that it happened on Plantation at the development.
And that's where the bullet,
that's where the shell was found.
I have two questions. One has to just do with the evidentiary issue of the tool mark identification. We've recently had, and I'm sure you've been involved in them, a series of cases where there's been questions raised about the comparative lead bullet analysis, which is not this.
Not this case.
The concern I have, and I guess we've allowed it before, but is this idea that anything in this world is 100% certain. And there have been at least federal courts that have said that an expert really in this area, certainly it doesn't need, I agree it doesn't need a Fry hearing, at least based on what we know now, but the idea that we're allowing experts to testify to 100% certainty. What is how would you compare the rationale of the courts that have looked at all the studies and said that although you can make a positive identification, you cannot say that this comparison is 100%. Even on DNA, you said it was 1 in whatever the quadrillions. But here we're saying 100%. So what is and I'm just not just for this case, but really cases in the future, and just knowing that some of these forensic techniques that seem so infallible may be fallible.
Well, first of all, it's kind of an interesting academic question here, because what you have is a firearm examiner whose qualifications and experience are unchallenged by the defense. Once you accept that machine tool mark comparisons have been in use for years, and I cite cases going back to 1937 in Florida, there's a microscopic comparison of the shell casings. It's not new technology. It's been around forever. Now, what these later federal district court cases, which to my knowledge have not been followed by the Court of Appeals, and it's certainly a federal district court case, judge's opinion is not binding on this court, but they seem to artificially limit the expert to a reasonable degree of ballistic certainty. But this court's decision in U.S. Sugar v. Henson and other cases make it clear that once you accept the technology is reliable and sufficient for admission into court, the remaining part of that opinion is the expert's opinion and needs to be weighed by the trier of fact. So what you have here, would you have firearm examiner Romeo lie about the degree of certainty? Because he's 100% certain based on his knowledge, training, and experience that this is a match. Those 3 shell casings, those marks exactly match the one found at the murder scene. So once you make the conclusion that it's reliable and sufficient for admission, anything else is a matter of weight. Now, the defendant could have brought in his own expert if he had one to challenge that opinion. So I think what's the next logical question? Are you certain to a reasonable degree of ballistic certainty that it's a match? Yes, I am. The prosecutor's next question, is there any doubt in your mind? No. So are we artificially going to limit the expert and his opinion and make him say something, I'm only 75% sure, when he's really 100% sure? Remember, this is
I'm just more concerned because we have, again, this is a pretty overwhelming guilt case that this science is still as strong and isn't under attack, and so I think your answer is a responsive one. I appreciate it. Second question just is about the principal instruction. If the judge had given the principal instruction, even if to 1 trillion, quadrillion possibility that some crazy idea of, again, somehow Salvador had to come out and finish this off, it wouldn't matter if there had been a principal instruction. Was there no principal instruction requested?
There was not, Your Honor, and the reason why is there would be no evidence to support that instruction. How could a prosecutor come in and say, well, even if Mr. Salvador came out there, but there's no evidence to support that, and usually you would want some evidence.
I guess the only evidence, it's not the evidence if there's, does he have an alibi for the time of the shooting?
We know that he does, Your Honor, but it was not allowed to present that due to a very charitable ruling by the trial judge.
So we don't know that, but what we know is that the same bullet that was at the scene was the bullet used at the shooting range, and what we know is that Mr. Salvador says he and the defendant were out there. So it's not as the other one, it's far out there, but would be the basis. But you're saying nobody requested it, and that's the end of that story.
And Mr. Salvador, I mean, while the defense wants to characterize him as a critical witness, the gun range log has Mr. King's signature on it. He was in possession of an unrecovered 9mm handgun at the time. You could entirely take that testimony out, and we still have.
Who was in possession of the?
Mr. King.
Oh, because
that's the only unrecovered gun. Mr. Salvador turned his 9mm over to the police. They chose not to test it for obvious reasons.
Okay, so it's Mr. Salvador that said that Mr. King also had a 9mm gun?
Yes, in fact, he put Mr. King's 9mm in his bag because Mr. King was unfamiliar with gun range procedures. But again, we know Mr. King was there shooting, not just from Mr. Salvador, but he had to sign in and provide an identification.
But then what's the deal with the bullets? That he then ran out of bullets? He was using Mr. Salvador's bullets?
Correct. He had none for his gun, and the obvious implication, Mr. Salvador didn't know if he got a hold of any bullets of his or not. So either he had his own bullets and loaded it elsewhere, or he took some of the ammunition at the range.
Well, it had to be the ammunition at the range because it's the ammunition at the range Correct. That matches the ammunition, the case.
And we know that Mr. Salvador provided ammunition. And again, Mr. Bolatin, I briefly addressed the relevancy. Justice Lewis, you had it exactly right. There's a logical chain here to show the shells were relevant. Mr. Salvador showed detectives the day after they were shooting at the range where he was standing with Mr. King, and they collected shells that were likely the same, 9mm. And then of those 47 shell casings, they narrowed it down to 3 that actually matched the one shell casing found at the murder scene. So, I mean, there's a logical nexus between all of the evidence, and frankly, it's so obviously relevant. I don't believe I need to waste any more of the court's time on that issue. And again,
Why would you have to do all 47? If you only have 3 of them that really were matches here, why not just the 3 of them?
well, to show that there is a painstaking analysis, I think, and you're right, they could have just said these 3 and just mentioned the other 40-some odd shells that were there, but I think they narrowed it down, and then through microscopic analysis, they could find 3 that actually matched from the range. So there was a logical sequence of events here, and they were clearly relevant.
So, when I asked you about the time sequence before, I guess in my mind I'm trying to fit Mr. Bolatin's argument into when could Mr. Salvador have gotten to the scene? Because if the last time he was seen, King was seen by a witness was at around 6 o'clock, murder occurred sometime thereafter. Do we have anything in our record that shows where Mr. Salvador was from 6 o'clock on?
Other than Mr. Salvador's testimony saying he was at home, he went to a storage shed and he was at home. And again, that's admissible evidence. So you have Mr. Salvador saying where he was at home. So, yeah, I mean, the Justice Periente had it exactly right. It's preposterous to think that Salvador galloped in at the last minute. How would he even know where Mr. King was? There are no cell phone records, no evidence of any contact whatsoever.
They say King erased his cell phone. Although, it seems to me under these technology they seem to have today, they can still pick out anything from your cell phones that they want to get. But but didn't Salvador erase the cell phone record of calls from King?
All but one, Your Honor, but again, we have phone companies here that have cell phone records, and there is no evidence of a single contact between Mr. King and Mr. Salvador.
No, we had King's cell phone.
Yeah, we have King's cell phone.
No calls to Salvador.
And we have, exactly right, Your Honor, we have King's cell phone, the one that Denise cried out for help on.
And do we have, and we actually, the
the phone records.
Actually got a phone record from his cell phone?
Exactly. Yes, Your Honor. We had the state introduced evidence from the phone company to show when certain calls were made, and it was a cell phone registered to Mr. King from which the victim was pleading for her life and to be let go. So again, just one other piece of many. We have forensic evidence linking King to all 3 crime locations here. He was caught red-handed leaving the vicinity of the burial, still wet and muddy from having buried the victim. Now, the fact we haven't found a gun, Mr. King was bearing evidence. He had 3 hours to dispose of items, and we know that he buried the body, he buried the shorts, he buried items and placed those items hundreds of yards away from where he buried Denise. So he certainly was trying to hide
I guess the
evidence.
logical question, though, is why wasn't the gun buried with all the rest of that?
Well, it probably was. We haven't found it. It's, he had a shovel and he was burying things. He had 3 hours to dispose of evidence. Now, we were lucky and we found, the police found the body the very next day. So we have absolutely compelling evidence, physical and otherwise, establishing his guilt in this case.
How old was the defendant at the time of this?
I believe he was 34 at the time of the crime, 35
Is there,
at the time of the
they raise a proportionality issue, and I don't see any basis at all. I think we had a case yesterday, there are all so many horrible murders that we see. But is there any, in terms of the mental health issues, here is a guy, any idea of the motive of he had ever done anything remotely similar to this as far as just stalking women? What was going on that day in his life that out of nowhere he would just commit this crime?
Your Honor, I don't know, but I do believe he planned this in advance. He had the duct tape, the means to, it was a well-planned, thought-out crime. The one mitigator found, and there was an extensive
it's hard
psychological...
to believe. A well-thought-out crime, you wouldn't be driving through the streets of a busy street where she's seen by at least several people, but be that as it may, I mean, I guess if the record doesn't show anything that would have been, did something happen in the days before that would have precipitated this? What was the mental, they found some mental health mitigation. Was there an explanation presented?
Your Honor, there is no explanation for this kind of evil, in my opinion, and there was none presented other than Dr. Wu coming in and saying he had some an abnormal PET scan that might make him liable. Dr. Wu, who said he had an abnormal PET scan which showed some brain damage, which was rebutted by Dr. Gamache.
Why did the trial judge even consider age as a mitigator?
That is a good question, because I went back at 35. He found it. This is, I think, a very cautious trial judge.
But at 35, why? I can't even see why there would have been any consideration of a 35-year-old using the age mitigator for him, unless there's evidence that he was functioning at some trial-like level or something. Do we have anything like that?
Well, he was clearly, no, Your Honor, but we do have evidence that he was of lower than average, and there's a dispute, either borderline. The state submits prior IQ testing shows he's in the average to low average range. But no, there was nothing psychologically. There wasn't an MMPI that we can point to.
But did the defense argue age as a mitigator?
I do believe they contended age as a mitigator. I know the judge found it, and I did find that curious, like Your Honor does, because 35 seems to be in the zone of you clearly wouldn't find it. I think it was just a charitable and very cautious finding by a trial judge, as was his finding of a single statutory mental mitigator. And my final comment here is Mr. Bolatin seems to recognize that this error is getting him nowhere on the guilt phase, but he now suggests that somehow he was prejudiced in the penalty phase, in that the jury could have found that he was somehow less responsible than some co-perpetrator. But the problem with that theory is the defense didn't even argue that. Whereas in the guilt phase, they held up Mr. Salvador and did what they could with him. But in the penalty phase, they didn't argue that Mr. Salvador was involved. They didn't want to insult the jury's intelligence, so that theory was never presented. So this court would have no evidence in this record, and certainly none that was offered by the defense, to suggest that any error in the guilt phase, and again, not conceding it, had any impact on the penalty phase. The defense never argued, and wisely, in the state's opinion, that anyone other than Mr. King was involved in these crimes. The state has nothing further. Thank you.
Very briefly, we couldn't argue in the penalty phase that Salvador was involved because that defense was eviscerated in the guilt phase. Now, on the question of the ballistics comparison, yeah, it's true that the state cites 9 or 10 cases, and the court counsel found 3 or 4 more going back to 1937 where evidence of ballistic comparisons have come in, but in the overwhelming majority of those cases, they weren't even challenged. There wasn't even a subject of an issue in those appeals. It was just a fact that was put in the recitation of facts in those opinions. I have not found any cases, and the state has not cited any cases where even traditional ballistics testimony has been fry tested in Florida.
Well, isn't that, I mean, the simple answer is that if something is well accepted, you don't fry test it.
Oh, Professor Earhart thinks otherwise.
Well, he may think otherwise, but our case law says that if the basic science is well established and accepted, it does not have to be fry tested.
But I don't think
that
the basic science has been established or accepted. First of all,
in this case, did someone present that evidence that it was not?
We were not given a fry hearing.
Did you
That's what we do at a fry hearing.
offer any such evidence?
That's what you do at a fry hearing. We asked for a fry hearing, and we were told you're not getting one. But what I'm saying is that this was not even traditional ballistics comparison anyway. Traditional ballistics comparison involves test firing a known firearm, and in this case, there was no known firearm. It was just a microscopic eyeball comparison of 2, or I guess 4 cartridge cases.
No testimony at all in this trial about the casings. There hadn't even been one found at the scene of the body. We would still have, my estimation, all of this evidence of Mr. King being seen with her, and I still think we would be in the same position we're in right now.
And I'm going to close with just one comment, which I've already made before, and I have to make it again. The evidence in this case is absolutely overwhelming, and in fact, the defense didn't even they didn't concede it, but they didn't present a defense as to the sexual battery or the kidnapping. There is no question that King committed those. There's no question that any error is harmless as to those. The question has to, was this a fair trial? I mean, I understand that you don't like the Robert Salvador defense. It's, it's not one anybody would have chosen, but it could be the truth. And it was, over the course of days of trial, it was torpedoed, it was sabotaged, it was eviscerated.
It just seems to me that no matter how you look at it, when you look at this evidence, and the evidence, as you concede, is overwhelming that he committed kidnapping and the sexual battery, the rest of it follows that he also committed the murder here.
That would be.
It seems to me that there is no other evidence on which you could conclude that someone else actually committed
I believe
the murder.
if the Robert Salvador defense had not been unfairly sabotaged, that would not necessarily be the case. And I believe the prosecutor believed it, and that's why he did what he did.
Okay,
everybody, even Michael King, gets one fair trial, and he didn't get one.
Could you sum up now in about 15 seconds?
I think I
or
just
have
did.
you already had?
I think I just did. Thank you.
Okay, we thank you both for your arguments. The court will now take a 10-minute recess.
All right.
See how you're going to argue it.
Supreme Court of Florida is now in session. Please be seated.
We now come to the third and final case on our docket for today, Atwater versus Cortum.
Thank you, Your Honor. I am Michael Davidson. May it please the Court for the Division of Department of Financial Services, the appellant in this cause. I believe I reserve 5 minutes for rebuttal. I have two primary arguments I'd like to address before the Court. First has to do with the misconstruction of the statute by the District Court of Appeal, and the second is the misconstrual of controlling case law dealing with accepted constitutional restrictions on commercial speech.
Now, if the statute is construed to be a complete ban for 48 hours on all communication, whether written or verbal, you had agreed in front of the first district that it would be unconstitutional. Do you agree with that, that if it's, still agree that if it's written or interpreted or actually says it's a complete ban, that is unconstitutional?
I would agree that it would be a complete ban, and I've been that before the district court, and I think it would be under existing case law. However, I'm prepared to address an argument today to expand some existing case law that might change that outcome. May I proceed? Okay. Let me get to the construction of the statute. The statute as written expressly controls only two things: face-to-face solicitations and telephonic solicitations.
Well, but now, wait a second. It's in all fairness, it starts off expressly talking about initiating contact. And those are express words in the statute. It says, public adjuster may not directly or indirectly through any other person or entity initiate contact. And then it goes on to talk about those other things. But the problem that you have here is that initiate contact seems to be rather broad. And I don't understand your argument.
Okay.
That it doesn't encompass these written communications. The fact that we have the specification of face-to-face and telephonic solicitation or entering a contract seems to point toward, well, we got to initiate contact must be talking about something other than those.
I think the way that you interpret the statute, and I go back to let's look at the Raila case in the Supreme Court. In talking about that situation, the court said, and it was Justice Powell delivering the opinion of the majority of the court back then, and they said that they were talking about a previous case of Bates versus State Bar of Arizona, where they're talking about we'd reserved a question from that case to be resolved today here in the Raila case, and it said, the court expressly reserved the question of the permissible scope of regulation of in-person solicitation of clients at the hospital room or at the accident site or in any other situation that breeds undue influence by attorneys or their agents or runners. And then they went on to say, they answered that question today by saying the state can restrict such solicitations.
But we're talking about, I'm sorry, I'm missing your point of how that's responsive to what I asked. I mean, the first question, it seems to me, is that we got to figure out what this statute means. Because I think that you have conceded that if it means what the first district decided it means, that there's a problem here.
If it were to constitute a total ban on all communication under current case law, I would agree and do agree. Okay.
And I'm not sure I'm not sure you've really presented it. You can't really change your argument here today. Okay. Well, I mean, you in terms of the argument you've made to this court, you're really bound by what you put in that initial brief you filed. You're the appellant here, and that's what frames this case for us.
It's both in the initial brief and in the reply brief.
Well,
it's not new.
Wait. Now, you can't make an argument in a reply brief that presents a different attack on what the district court did. I don't think, but obviously that's something we've got to we'll have to sort through.
let me try and get to your first part of your inquiry here. Okay. The point is in the Raila case, the court recognized that attorneys often use people that are designated as agents or runners to solicit for them. Okay. it's common practice in the public adjusting profession to have runners solicit for them as well, okay? And I believe there are even companies that employ runners that put them under contract to the public adjuster. The point is that directly or indirectly was meant to apply to the runners, the unlicensed runners, as well as the licensed public adjusters. Otherwise, if you don't expand it to that scope, then the runners will take over all the solicitation efforts, and the statute will be evaded.
You're explaining the directly or indirectly through any other person, but what Justice Kennedy asked you about is the initiate contact, because, you know, one of the things that I did in going back is looked at subsection 5, and I'm going to ask your opponent to address that, because that is a complete ban on the time of day and the week, not do it on Sunday. And so the question I'd have, though, is, doesn't initiate contact without any qualifier? It doesn't say initiate contact in face-to-face or through telephone. Doesn't that initiate contact encompass everything?
It says to initiate contact directly or indirectly through any other person or entity.
No. What it says is a public adjuster may not directly or indirectly through any other person or entity initiate contact. Now, the way I would understand that, and I think really the only reasonable way to understand that part of it, and I will concede, this is not the most elegant language. But you know, the reality of our statutory interpretation labors is that we are not typically dealing with elegant language, because if it was elegant and perfectly simple, there'd be no question that would reach the Supreme Court. But the way I think the only reasonable way you can understand that portion of it is that when it says a public adjuster may not directly, that means the public adjuster cannot do it himself or herself directly. The directly is referring to action taken directly by the public adjuster, or indirectly through another person or entity. So neither can the public adjuster do it, or acting through another person or entity, indirectly do it, initiate contact. Now, why doesn't it just simply mean that?
I think the distinction you're making is an important one. Why can't they act? It's always been our contention that the statute in these regards regulates conduct and not speech. The statute does not say, unlike all the other cases where the government has been criticized for overreaching, it does not say you cannot use these words or you must use these words.
No, but you're not answering
any words.
But the question that I have is, and I don't know, you answered it, and again, I'm sympathetic to your argument. The state here is saying, listen, we didn't mean to have this total ban, and we thought what we were writing here was just a ban on telephone and face-to-face. So, and that's what you're saying is, no, we didn't mean it. And what we're saying is, well, good, that's great, you didn't mean it, but we got to deal with what's said. And my biggest issue is that initiate contact, which I don't think was in the task force proposal. You know, if it had simply said indirectly through any other person or entity engaged in other words, what's the purpose? Maybe I'll ask you that. What would be the purpose of initiate contact that wouldn't otherwise be fulfilled by engage in face-to-face telephonic solicitation or telephonic? Why do they need initiate contact?
I think the intent of the words initiate contact was restricted to those two modes of conduct. You'll not initiate contact through face-to-face solicitation or telephonic solicitation.
But it doesn't say that. It says or. It says 3 ors. No initiation of contact, no face-to-face telephonic, and no entering into a contract. You could write this, we could all write this, to say what it means, you know, what it was intending to mean. Because if you look at the one before it, it is a complete ban on the conduct during specific periods of time. But this one is, I think it's the initiate contact that's, to me, the problem. Because
Keep in mind, the statute allows the homeowner to initiate contact. Doesn't forbid that. The homeowner sees a written solicitation, which could be anything from a door hanger saying, here's your top 10 tips to get your claim adjusted properly.
But they're saying that's initiating contact, and it's prohibited because it doesn't say initiate contact by phone or in person.
Well, I understand your argument.
It's not my argument. That's the interpretation that was given by the first district, and it's the one that seems potentially, to be the most reasonable one. The question is whether your argument, you haven't really answered. What does initiate contact without qualifiers mean in this statute?
Let us go back to the task force the legislature commissioned.
I'm asking you that question. Okay. What would you, if you're reading this, you don't know about the task force, you read it as a public adjuster, what would you think initiate contact without a qualifier means?
I think it means neither I nor my runners can initiate contact through phone or face-to-face solicitation.
But the problem you've got with that, with all due respect, is that's just not what it says. It's got these ors. And it just, again, it strains credulity to think that that's what it says. It just doesn't say that. And I understand that might have been what they meant, but we can't deal. And I mean, I don't think we should deal in what we think they meant. We've got to look at what they said, and what they said here just can't. I don't see how it can be squared with your interpretation. And I'm not, I understand. You're dealing with this and trying to do the best you can with it. Those words are very problematic, because when I think about the door hanger on the door that you send somebody up there to put on their door, that's initiating contact, because you're hoping that's going to generate some business. And I'm not. That's the reality of it, and I think the way this whole thing is teed up, if it means that, then the way it's been argued, and maybe it wouldn't make any difference the way it was argued. Candidly, I'm not sure that it would, but I think you're over in Central Hudson land. I have trouble seeing why you don't end up in Central Hudson land, because this is about the communication. It's not about burning a draft card. Okay, that's not what we're dealing with here. We're talking about the communication of information. It's commercial information. But if you end up over in Central Hudson land, it's problematic, isn't it?
Well, as you have obviously made up your minds in this regard, and I don't say that pejoratively.
No, I haven't made up my mind.
I see where the flow of the argument's going here.
Show it. Give us an argument that shows why that those questions have a faulty premise.
Well, the best I can do, and I've already said this, the best I can do is to say to you, I think the statute was designed to expressly prohibit two conducts: face-to-face solicitation and telephonic solicitation. That's the only things that are expressly addressed.
And what you're saying, I just want to make sure about this. You're saying, and I think that in face-to-face or telephonic solicitation modifies both engage in and contact. Is that your argument?
I'm saying that the initiation contact is modified for any other person or entity. Okay, and another person or entity, it would be a runner or a company that hires runners and assigns them to a public adjuster. The idea is that you don't have a person either on the phone or in the face of the homeowner during the first 48 hours. That's the idea of the statute.
What does the directly mean?
Well, that means the licensed public adjuster, him or herself, cannot initiate telephonic or face-to-face.
Okay, so the directly refers back to the public adjuster, and then it refers forward to engage in face-to-face or telephonic solicitation, skipping over the initiate contact.
No, it's directly or indirectly, and the indirectly covers the runner situation. Okay, and so it's our construction, the statute, that basically, if a statute does not forbid something expressly, it allows for it. and it does not expressly forbid written communication, we think therefore it allows for it. I understand your construction and your concerns. The best I can rejoinder with is that if the statute doesn't expressly forbid, it allows, and we think given the task force history and the fact that the legislature accepted that recommendation and did not materially change it to say, oh, no, wait a minute, no, we don't want any communication at all, I think.
Because they were told it was be unconstitutional
Yes,
if they had
were.
every ban.
And so the phrase through any other entity was inserted to prevent that problem from cropping up. Those are the best answers I can give you on that.
So
on that
initiate contact, in your argument, really is redundant.
It's a redundancy except to the extent, all it really means is you don't initiate contact through another person or entity over a telephone or in person.
So the legislature really should have put the word by where they have the word are.
Frankly, the legislature should have said, you can do this and you can't do that, but they didn't do that.
But even in this sentence, if they had put the word by instead of or, by instead of or, then we would have a clearer statute.
It would be a superior authorship of the statute.
And isn't the beauty of our separation of powers that the legislature has an opportunity, whatever we do at the next session, to either change the wording or...
We've already so advised.
Now you're your candor. You are a little bit into your rebuttal time.
Okay, well,
here, but you can continue.
Let me finish my second point here, and that is, I want to point out to you that under the Heralick decision, the U.S. Supreme Court allowed much more stringent restrictions on lawyer solicitations for a number of reasons, one of which was that lawyers are trained in the art of persuasion, and therefore they can possibly talk people into entering into contracts they might later regret by using that persuasion and those persuasion powers. Well, I want to submit to you, I think public adjusters stand in that same relationship to their homeowner clients.
Now, are you saying this if there was a complete, you're now saying assume there's a complete ban, it's okay? Is that your alternative
For 48
argument?
hours.
Okay, so you're saying we should, if we interpret it as a complete ban, it's still
it can still pass constitutional muster, okay? Because don't forget, the Heralick case said a complete ban on lawyer solicitation. What was it? And in Florida Bar versus Wentworth, 30 days was a complete bar on solicitation for 30 days. Here we're only asking for 48 hours. So the point I want to get to, let's compare. To become a lawyer in the state, which will allow you to adjust insurance claims, because it's a special exemption in the statute to allow lawyers to adjust insurance claims, you got to go through 3 years of law school, which gives you a whole variety of topics you study in 3 years. You come out of law school, you pass the bar exam, okay? You pass the bar exam because the exemption that you're given as a lawyer, you can go adjust insurance claims, even though there's never an insurance claim adjusting 101 in law school. Okay, you will be using that same persuasion to talk your clients into a contract with you, and you'll be using that same persuasion to talk the insurance company departing with its money in favor of your client, and you're in that money stream between you and the insurance company. That's what a lawyer does, and he uses all.
I don't really understand that analogy because lawyers are really pretty much well known in the public and what lawyers do and their persuasive powers, but quite frankly, until this case, I wasn't even aware there were public adjusters. I've always called my insurance company and they sent an adjuster out. And so, I don't think that public adjusters are people the public even knows about.
Well, at trial level, I suggested they probably ought to advertise more, but that's beside the point. The thing is, public adjusters...
Not the first 48 hours.
The public adjusters hold themselves out to be experts in claims adjusting. I mean, there's exhibits in the record here that says, we have great expertise in these things, trust us, we'll handle your claim properly.
But you know what you're getting, and I know what you're getting into, they should be looked at as lawyers. My cynicism about the motivation on this is that the task force report showed that people who had hurricane claims that used public adjusters got 750% more on their claims, even when you took out a percentage. And it seems to me it's the insurance industry that is sort of saying, yeah, we don't want these guys here or girls for the first 48 hours because we want to do our thing. Well, those of us that have dealt with insurance companies for most of our career, we sort of wonder about what that motivation is. Well, so I wouldn't exactly be saying these public, that the motivation of the statute was entirely to protect the consumer.
Well, let's not forget, this came to the court from a bench trial, In a bench trial, there was testimony unrefuted in the record that rarely are insurance claims even initiated, let alone settled within 48 hours. Okay?
But they all said that the first 48 hours, you got to know what to keep, you know, whether the belongings could be gone.
And that's where written communication would allow you to put the door hanger on, the flyer, the electronic, whatever you want to do, and say, here's your top 10 tips. Don't do the following things before we get to you. Okay? And that would be allow the homeowner to know those things. But what I want to get to before I run out completely out of time here is I think in the final analysis.
You're actually already out of time.
May I have just 1 minute, perhaps?
Would you want to, I'm going to give you another minute, but do you want to save it for rebuttal, or do you want to just go ahead and do it?
Let me just say this. I think when you final analysis, and it's in the brief, if you read the briefs, you'll see that we think public adjusters and lawyers stand on equal plane, at least as far as claims adjusting. They should be looked upon as limited duty lawyers for claims adjusting and held the same standards lawyers are. And if the lawyer speech can be restricted, so can the public adjusters, constitutionally.
Yeah, I'll allow you an additional minute for rebuttal if you
Thank you, Your Honor.
like.
It pleases the court. My name is Wilbur Bruton. I'm representing Mr. Cordham.
Can I ask you about the subsection? If we read, let's take subsection 5 of the statute. Was subsection 5 added at the same time as subsection 6?
Is that the Sunday?
Yes.
You know, I really don't know because we elected not to pursue the Sunday issue.
Yeah, I have a feeling. And that one, they use the word, a public adjuster may not directly or indirectly through any other person or entity solicit an insured or claimant by any means. So to me, when the legislature, the section before, knows how to say, you can't do anything at all, and you can't do it between 8 a.m. and 8 p.m. You can do it 8 a.m. to 8 p.m. Monday through Saturday, but not before 8 a.m. and not after 8 p.m. and not on Sunday, right? And that's clearly a ban on doing anything by any means. So my question is the legislature intended number 6 to be a complete ban for 48 hours? Why didn't it just say, use the same language that they may not directly or indirectly through any person or entity solicit an insured or claimant by any means for the first 2 days?
Well,
it's right. I mean, and if they're writing it at the same time, we do look at the issue of, because I don't think this is, by the way, clear and unambiguous, number 6, we look at other provisions within the statute. And when you look at that one is plain and clear as to what it intended. This one appears to be an attempt, albeit somewhat awkward and maybe even, whether confusing, to try to do what the Mr. Anderson, Davidson, has said, which is to limit telephonic or person-to-person communication.
You may well be right on that, but I still think that's unconstitutional because in the Edenfield case, which was a Florida case that went up to the Supreme Court, it specifically spoke to banning telephonic solicitation.
Okay, so that was what I was going to ask you. Because I didn't think you were making that alternative argument. You're saying that even if we interpret it the way the legislature intended, that is to only ban telephonic or person-to-person, it's unconstitutional.
Yeah, the initiate contact means you can't see anybody. And I have often wondered how you would walk on somebody's property with a door hanger and not be initiating contact, but that's not our point here. Our point here is there's a whole line of cases. And before I get into my argument, I want to point out one thing. There is a huge amount of stipulations in our appendix number 3. And I will tell you that the department has stipulated that the bottom lines are other people that can cause you financial harm, your cleaning services, et cetera, that are not restricted, that can come in contract or smoke mitigation.
But isn't since I also hadn't heard of a public adjuster, I confess, till more recently, and it looks like this state, like it leads, and in so many ways leads the country public adjusters. First of all, a public adjuster to me sounds like something that the government would have authorized. So that word itself gets me a little nervous. But they're licensed by the state, and they hold a fiduciary duty, and they can enter into contingent fee contracts?
They can enter into contracts
Sure
that provide.
sounds like that sounds to me like what a lawyer can't do in the first 48 hours.
Well, Your Honor, let's understand.
Can they do that? Can a lawyer do that?
Lawyers are not included in this.
No, but I'm
ban.
asking you, can a lawyer do that? Go to somebody
Right.
who's just had their house destroyed in the first and say they'll represent them.
Yeah.
We don't have a ban on that.
No, and they let me back up just a little bit. Public adjusters were approved 50 years ago by the Supreme Court because there was a statute around for them. Public adjusters came in, and when this organization got organized, and Mr. Cordham is a member of the organization, the first thing he did was pass an ethics provision into the Florida law. That ethics provision is enforced by DFS. The stipulations indicate that there aren't violations other than technical violations that they've investigated ever since they've been doing this. I think you're right. It's the insurance companies that are the issue. And for those who haven't had a house fire and one that burned down, you really want a public adjuster when you have a problem, because it's hard to understand the rules. But let me just get to my argument if I can. The first 48 hours after you have a loss is when you got mitigation issues. We've stipulated in all the stipulations, those are the most important times for a policyholder to be able to have the services of a public adjuster. So we're not bad guys. The issue here is some people would like to try to make us out, like the amicus that popped in. But the issue here is communication to a person from a person is commercial free speech, and that's protected by the First Amendment. So you can't ban telephonic solicitation and face-to-face communication. All the case law that we have, the progeny of Central Hudson, are there. The Bradford case by this court, same result. This is barring PIP claim solicitation. Edenfield that I just mentioned, Florida doesn't have any evidence related. They went the Hudson test. Insurance Bureau in Pennsylvania, they struck down a 24-hour ban almost identical to Florida's. Pruitt versus Harris County bail bondsman after your criminal cases today, that no ban on communications because it may be valuable for the speaker and the potential customer. Virginia Board of Pharmacy.
So do you contest that any of the Central Hudson four-prong requirements could be met in this case?
No. I think the first two, definitely. The first district said they met the third, but I didn't agree. But the point is, this statute.
If they don't make the fourth one, game's up anyway.
Game's over. And so the bottom line is, as far as the third, the harm's got to be real. It can't be imagined. It can't be speculation that some rogue public adjuster is going to violate the ethics statute and traumatize somebody at a certain point in time.
Well, it is important. I mean, the reason it's important on the third, because if we interpret this as a total ban and say it's unconstitutional, you're actually arguing, even if it's not a total ban, it's unconstitutional. But if it doesn't meet the third prong, then any type of restriction would be unconstitutional.
And I think it is, because the touchstone of all the cases is that speech that proposes a commercial transaction, if not unlawful and not misleading, is protected by the First Amendment.
Except for lawyers.
Except under Orlick.
Except for lawyers.
And that applies strictly to lawyers.
Well, when you say strictly, I mean, that's except
they're
for lawyers.
runners.
And, I mean, to me, the rationale of that is absurd. I mean, there are carnival workers that talk people out of their hard-earned money to play stupid games at a carnival. Throw your money away. there are all kinds of financial advisors that go in and take advantage of people. So, I mean, to say that lawyers are the only group that has such training that they can talk the money out of the pockets of a homeowner is pure sophistry.
Well, the Ulrich case was not a public adjuster case.
Oh, no, I understand. I understand. But the point being is that I think the point's been made here. In fact, the house burned beside me in Miami. You know who showed up? A lawyer that I happen to know and a public adjuster. That's, what are you doing here? I said, I live here. What are you doing here? And the public adjusters were chasing it just like the other, what we say, chasing lawyers. So I really don't see a big difference between the two. Not that you should ban either one, but if we've created some of these exceptions, what's a fair exception here?
Well, and I think the Supreme Court, and I filed 2 cases of totally different issues as supplemental authority. I mean, the Supreme Court of the United States is expanding the commercial speech as we go, and for all practical purposes, I think the rule of law today is very simple, and that is that if it's a commercial transaction and it's a lawful activity and it's not misleading, it's commercial free speech, and the state can ban it if they come up with a real reason to do it. They can prove the harm, and they can show that what they did is very narrowly tailored to accomplish that good, then I think they can do that.
Well, here
but
we have, though, we do have a principle of deference to the legislature, of construing a law in a way that will uphold its constitutionality.
Not in free speech cases. The burden is on the state. The burden is right on the state. That's the central Hudson land. The burden is on the state to prove it up, and you can't defer. And that's the path that the circuit judge unfortunately went down, was interpreting legal argument at trial as being the department's position. And unfortunately, it's just a statute.
No, I'm talking about the issue as to whether this is a total ban or interpreting the statute, that the legislature intended not a total ban, but a ban on face-to-face and telephonic communications, which are clearly, because, you know, somebody dropping off a door hanger or sending an email, it doesn't have the same impact anyway as a person showing up at your door the morning after you've had this catastrophe at your house and saying, I'm here to help you. You know, so it's not to me in the same category. That you're saying we would have to, even if it was interpreted that way, it would still be unconstitutional. And I'm not sure I see that under that would be a narrowly tailored statute then. That is, if it only banned the face-to-face and the in-person and the telephonic.
Justice Parenti, the problem is that there are other people that swarm to your door, which are contractors, which are mitigation experts, and so forth. It's all stipulated to that there is no time restriction on insurance company adjusters, cleaning services, contractors, roofers, smoke mitigation, or water damage experts, all who may freely approach the policyholder in the aftermath of a claim.
You see, this is the difference I see, and we know there are unscrupulous people in every walk of life. But if you've just had your roof has come off, you're probably going looking for that roofing person. So if a roofer comes here to your house, okay, and I think people understand things like what if something might cost or whatever. But when you get into this realm of an attorney who's going to say, I will help you, you should not sign up with you shouldn't sell with the insurance. We're not here on attorneys. But the public adjuster is, in this situation, is doing exactly what the attorney would do other than being able to file suit.
Okay.
Aren't they?
Not really. Let me put this into
how not?
Let me put this
Tell
into.
me how not.
Okay. Well, first of all, they do owe a fiduciary duty like a lawyer does directly to their client. They do know how to adjust claims, and I'm not sure most lawyers do, because I had a fire and I didn't know how to do it. And I don't know why lawyers always show up at places like that anyhow, but let me try to put this in.
Did they also enter into contingent fee contracts with
more likely than not.
Sure sounds like a lawyer to me.
If I can just have 30 seconds on this issue, the bottom line is that...
Got about 6 minutes.
Yeah, I'm trying not to use the time, but what I think I'm trying to say is, these people that I'm talking about, scrupulous, unscrupulous, assume they're all honest. The bottom line is they can cost you money off your policy in the first 48 hours when you don't have a public adjuster that can stand there and say, no, this is the way to mitigate your loss, not hire the mitigation expert to do it, because you need to have a plan to do this. Otherwise, you'll be spending money unwisely. Public adjusters do a lot more than just collect a contingent fee. And in reality, all I'm saying is what they do when they approach people is commercial free speech, and it's protected. If you took the initiate contact out and everything out and said you can't have telephonic or face-to-face communication, you're banning commercial free speech of a lawful activity.
But that version of the statute really is not the way this whole thing has been litigated, but it's not the way the first district dealt with it. I mean, that's not...
And it's not the way I dealt with it.
Right.
And my position is, it says you can't initiate contact directly or indirectly or through any person. And I think that means any way. So I waive the rest of my time.
You're welcome to do that. Thank you. Thank you.
Very briefly, Your Honors. While it is, Mr. Bruton said that the courts are expanding on commercial free speech situations. Let me bring to attention a quote from one of the cases he recently supplied us with, the Sorrell case, Sorrell versus IMH. It's one of his additional authority cases. It says, it is also true that the First Amendment does not prevent restrictions directed at the commerce or conduct from imposing incidental burdens on speech. Okay? So, but let me get to a couple of things. Justice Parente, the big difference here between these other people that swarm to the site and public adjusters, the PAs use contingency contracts. These other people don't. There was nothing in the record that shows anybody of these other people use contingency contracts, okay? So that's a big distinction here. That's just like the lawyers. In fact, the only real difference between a lawyer and an adjuster coming on your premise at that point in time, the lawyer has no fee cap. The public adjuster does. So the lawyer is probably going to charge you more than the public adjuster will for the same services, and the PA is probably better qualified. But
So then we ought to encourage them.
yeah. So
you better get them there before the lawyers.
I'm going to get one next time, I can tell you that.
So, and let me say this briefly. We don't contend.
And seriously, it does sound like they're doing a very important service.
No, I was just about to say that.
Right.
We do not contend public adjusters are uniformly bad people or uniformly in the ambulance chaser category. There's a number of good ones out there. They do very good work. I've seen them before. But as any regulatory body does, just like with the Florida Bar, the regulations are there for the people that are not ethical, not so honest, not so scrupulous about what they do. The rest of the people, those regulations don't worry about. We don't care about this.
But this regulatory measure that we're dealing with here is not aimed at dishonest or unscrupulous conduct. It is aimed at all speech during a certain period of time.
Judge, just as you don't know which person's going to rob the bank, you don't say only bad people cannot rob banks. You say nobody can rob banks. Okay, you never know who's going to be the scrupulous, the unscrupulous person.
Well, but there's not a bank being robbed.
Well,
I mean,
to the extent someone is talked into signing a contract they would not otherwise sign within 2 days, and we have depositions in the record that people have said that. If I'd had the time to consider the contract, I never would have signed it.
Well, they've got
that is sort of robbing the bank, with all due respect.
If you would, I think we're
going
over now about 3 minutes.
All
so
we
if
want
you
to
could
say,
wind up in about 15 seconds.
All we want to say is that the regulation of public adjusters is a legitimate governmental interest. And if you do it constitutionally, it should pass muster. And we think here that because they stand on at least an equal footing with lawyers regarding commercial speech regulation, that they should be regulated just like the lawyers are, and the temporary bans should be allowed. Thank you.
We thank you both for your argument. That's the last case on our docket today. Court is now adjourned.
All rise.
watching the Florida Channel, a public service of the Florida Legislature, WFSU TV, and Florida State University.